So we are in an open meeting, a training meeting on open meetings, and I do have that responsibility in the civil side of the county attorney's office, and I knew nothing about it to speak of except for some time when I served on the judicial council, and I wasn't the one who had to keep track. I learned a lot in this process. I am following Dave's PowerPoint as I indicated. It's a very well done, concise statement of the law, the obligations. I will not read anything verbatim. We're going to go through these points and then consider them. I really need you to ask questions if you don't understand something. One of the most important things as we deal with these rules and how to get our arms around, and most of us don't have familiarity with open meetings rules, reporting rules, minutes, etc. One of the most important things I find is to know why we do it. Then when we understand why we do something, we then move into how we do it. Now, I'm just going to start out here. Now, you've got that? Maybe I'll try and do it from here so you don't have to worry.
I don't know where you're...
Kent doesn't really want to be here. This is going to surprise you. And he was going to flip one of these about every 6 seconds. And that would have been done pretty quickly. But I'll see what I can do here. Oh, do I go left? There you go. So this is a legislative requirement that the people's business should be done in public. And we are all here. Most of you are volunteers. You're here because you care about what's happening in your community, and you maybe are doing this because you don't like what someone else did. You can't do a very good job in dealing with open meeting, in dealing with what's going on in the public's business unless you know what's happening and how it's happening. It's critical to understand the process. So the legislature makes it really clear that we must take our actions openly and conduct all deliberations openly. Now there are some exceptions to that, but we'll get to those in time. The Act requires us to take our actions openly. It ensures deliberations allow for public scrutiny. Now, there are some exceptions. One is the judicial exception, which is to a very large extent the process is closed. For a lot of you, you're engaged in a quasi-judicial function, which means separate from policy making, separate from administrative issues, you're making decisions where you have to make determinations from facts, weigh and consider what is correct, and then apply that to come to conclusions of law. They are not things that have to be done in a public setting. We'll give some examples shortly. In fact, there's that exception. We can move on from there. The open meeting rule applies to a legislative body. Many of you have a partly legislative, partly administrative or executive role. The legislative component is by far the most important that requires this open process. You can see it, these go back to the Constitution, statutes, rules, ordinances, or resolutions. You don't have an issue unless there are 2 or more persons present. I can back up. You don't have an issue with 2 people, but the rule doesn't apply if there's less than 2. It applies when we have circumstances where money is spent, distributed, or supported by tax, and you have the authority to make decisions or recommendations that do the county's business or your boards, special districts, and so on. We are not, of course, well, there are city councils within our domain, but for us, we're talking the county council, the planning commission, the board of adjustment, project committees, special districts. Not affected by the Act, the county manages deliberations and work. The chair of a public body, when acting in an administrative role. Political parties, now that's an interesting exception. We've all sort of sometimes chafed under that. Political parties can determine whether indeed they will conduct their business and let us see the process of how they do things in public. The Republicans have chosen to have caucus options where they do not open them to the public. Right now the Democrats have chosen to make it open. And I think in all fairness, as a Democrat, one, I should disclose I'm a Democrat, and two, I should admit, when do the Democrats ever get to make a decision that's going to be law anyway? So I wouldn't worry too much about that one. If the Democrats were the majority, we might find a flip in that little rule. Community councils, staff meetings. After I'd been county attorney for less than a month and started to see all the concerns about open meetings and the care in which we go into a closed session and not, I started to get paranoid when I talked to my staff on Wednesday morning meetings. I had to be calmed down by David to make it clear that, yes, we can talk between ourselves. So, staff meetings, not subject to open meetings. A meeting, convening of a public body, quorum present. Doesn't matter where the meeting is held and how it is held. Now, this is going to be an ever-expanding area in how we meet. But there must, you'll see shortly, there must be a physical location from which the meeting is conducted, although everyone can participate electronically, by telephone, by Skype. I think if all the people in the meeting are under 30, they can do it by text. Maybe that's under 20, I'm not sure. But those people can do it fast enough to get the work done, and that's really cool. What is not a meeting? A chance meeting. A social meeting. And who can see some room for abuse there? They actually had the sense in the statute to say the chance meeting, social meeting exception is not to be used as a device to avoid the public meeting rules, the open meeting rules. So try and remember that, you know. I mean, you can only justify so many parties a week. And if the party is only the governing body or the board, I think we might be looking a little closely at you. Oh, by the way, when I say we, I learned when I got to the end of this presentation that who can enforce the rule? The county attorney, the attorney general. I get to do that, so. Okay, email. Email's a tricky one. We all communicate that way now. We need to do a great deal to get a sense of where things are, to know if we need a meeting, etc. But we cannot vote by email and make a decision. And it's very easy to do it. So watch that one. I mean, you just get excited and suddenly everyone said, yes, I agree, I agree, I agree, I agree, and suddenly you think you have a decision. No, you felt, you put your finger in the wind, you maybe had a straw vote, you didn't have a vote, and stay as far away from that as you can. I think maybe I need to go back on that. I wasn't. Apparently I don't know how to go back. Let's get into our closed meetings, since that couldn't have been important enough to stay with. Discussing an individual's character, professional competence, or physical or mental health. This includes all personnel discussions. You know, I found that really interesting because we'll talk a little more in a minute about the mechanics of getting in to a meeting, what you can do in it, but personnel, boy, I thought that sounds like something that could cover a multitude of sins. Then I remembered a book I was reading. I'd like you to think I'm a highly intellectual person who only reads in the Latin and Greek and the classics, but actually I read a lot of trash. Any of you know John Sanford? No, it's not trash. He has the Prey series. The Prey series are good mysteries. He also has Virgil Flowers. I read this one about 6 months ago, and it really resonated with me because it's a great teaching device and a help to know what you can do in a closed meeting. The Buchanan County Consolidated School Board finished the public portion of the monthly meeting. The last speaker had demanded to know what the board was going to do about buying better helmets for the football team. You know, the sort of thing that keeps us going in these meetings. The board talked about that in an orderly fashion, each in his or her turn. The 5 board members, the superintendent, the financial officer. I'm not going to give you the whole thing. That done, the board ran everybody off. That's how they did closed meetings there. They ran everybody off, with the excuse that they had to deal with personnel matters, which was almost true. Jennifer Barnes, the big-haired chairwoman and one of the 3 Jennifers on the 5 board, said, I guess you all know what's going on. The fact is, if something's not done, we're all headed for disgrace and prison. Anyone disagree? Well, of course, they didn't disagree, but what can be done? So what are we going to do, says one. Well, we all know what's got to be done. The question is, can we sustain it? The 3rd Jennifer said, I'd rather go to prison for embezzlement than first-degree murder. They all went, and wished she hadn't put it quite so starkly. She persisted, "We know what we're talking about here. Randy, how would you do it?" "Well," he says, "I've been scouting him. He runs right after dark when it starts to get cool. I'll come up behind him, shoot him in the back, he won't suffer." Now, this is about personnel. They're talking strategy, so that's legit, right? So I'm not sure I'm seeing a problem yet. If there's nobody around, still strategy, I'll get him right at the bottom of that last hill before he goes back up to his place. The ditch is steep and all full of cattails. Nobody will see him down there. Barnes, the chairman, looked around the room and said, "Okay, we can do this. Let's see a show of hands." It's unanimous. Or it's prison. Do we kill Clancy Connolly? They all looked around at each other, each of them reluctant to go first. Then the fat man raised his hand, and then Kearns, and then the rest of them. "It's unanimous," Barnes said. She unconsciously picked up her gavel and slammed it on the desk. So, I mean, what's the problem with that? They closed the meeting. I'm sure they did it right. They discussed personnel. They probably discussed character. I wasn't real clear on that. Well, I think they did, because they thought this guy was a snoop. Then they discussed strategy to kill him, take care of the problem. Now, there is a problem here. They took a binding decision. Shouldn't they have gone back into open meeting to decide whether to kill this guy? Well, perhaps. But, so moving along, we could take something like personnel and perhaps corrupt it. I would say it's one that would be very easy to do that with. Strategy decisions to discuss collective bargaining. Well, we don't exactly have collective bargaining as such, but certainly strategy to deal with compensation issues are probably okay. Discussions regarding security personnel devices or systems, which we've become very careful to protect in this day and age of so many threats. Investigative proceedings regarding allegations of criminal misconduct. Discussing pending or reasonably imminent litigation. This is a tough one because there's often arguments what's pending or imminent, what is an appropriate discussion, what are the roles of the lawyers in the room, but this is totally appropriate, and because of the attorney-client privilege, much is protected even more broadly if you're having a meeting with your lawyers than it would be just under closed meeting, open meeting rules. Strategy sessions to discuss the purchase, exchange, lease, or sale of real property, something that's very common in Summit County, and we can all understand that. It's so logical that we need to protect prices, valuations, competition. We're allowed to go out and try and get a good deal for the county, for the smaller entities, for the open space, for the rec district. So again, these exceptions really are pretty reasonable. Are there any meetings that must be closed? No, there are not. And that's nice. I mean, I would say as a general rule, do what you can in open. Don't close if there's no good reason. Don't close if it really doesn't help, but you've got to be sensitive. Certainly when individuals are at issue, and you've got to protect the people's money by getting good deals and making good decisions, careful strategy, etc. But nothing is required to be closed. Here's where we've got to talk about how to do this, and this gets important, and one thing our county auditor and the audit committee are looking at and will do in expanding some of the audit processes is audit how closed and open meeting issues are handled. They'll be looking for the appropriate motions to open or close. They'll be looking for the minutes, and let's just talk a little about that in some detail because that's very important. There can be no decision to go into a closed meeting unless we're already in an open meeting. And it's an open meeting that has to be properly noticed, which means date, time, place, agenda. We need all that. Then in the meeting, we have to give a reason why we're going in, but not the details. Litigation, personnel, property purchase. That's good enough. But that has to happen. Now the votes. 2/3 of the body present must vote to close the meeting. So if there are only 3, 2 is fine. That's really not an onerous requirement. And you've seen there the reasons for holding, and has to be on the record who voted to go into the meeting or against going into the meeting. And the location. And as the meeting follows the open meeting, the closed meeting must be at the same location, not the precise room, but the location, so there should be no question about where that's happening. What is forbidden? One of the biggest things is these final steps in the non-judicial or non-quasi-judicial proceedings. You cannot approve any ordinance, resolution, or appointment, but you can talk about them. You may not interview a person to fill an elected position, but again, I guess you can talk about them, but I don't think that's just my gossip side, okay? You may not take final action except in the judicial or quasi-judicial decision. And then the final vote must be open and on the record, and all judicial or quasi-judicial decisions must be announced on the record. Okay, notice requirements. Yes, indeed, there are. The presiding officer does have discretion to allow items raised by the public to be discussed without prior notice, so long as no action is taken. It's sort of another public comment like we had a little while ago. Normal posting, at least one newspaper of general circulation. The Use Our Public Notice website. Are you all familiar with that? It's a great tool. It's out there. You can Google it and find it. I should have come with a website address for you. I apologize, I did not. But that exception does not apply to the county or any of your bodies. The budget under $1 million, so you must use that notice website. It's very important because it has been deemed to convey notice in cases where many people don't get it. But the goal is that people will know to go and look there. Some of you may recall the soccer complex in Salt Lake where there was a huge fight over the bonding a few years ago. And that huge fight, because I live here and I was still on the bench, it turned out that every judge who lived in Salt Lake City was disqualified, so I finished up doing the hearing on the validity of the bond process. And one of the biggest issues was it wasn't always in a paper, but it was on the public website. And I did find the bond to be appropriate, and that was appealed, but I was affirmed on that. So it's a big tool. It saves you money, but on any of these issues, if you've got questions or cannot get the information, contact me or any of my civil attorneys. Just our initial and last name, rhill@summitcounty.org, and we'll get you answers and we'll get you forms or whatever you need. At least 24 hours prior to the meeting. The agenda, reasonable specificity. You've seen agendas today, you've seen so many of them. They don't have to be long and drawn out, but they have to give people a sense of what there is, date, time, and place. Emergencies. I'm not going to spend any time defining an emergency. If you have one, I think you really should talk to the lawyers and if you're not comfortable. But an emergency is an exception. They do exist. Time is of the essence. And the minutes should include a statement of the unforeseen circumstance. Records. There must be records. They must be taken at both open and closed meetings, but they're different. I'm looking for someone who's taken a lot of those. When I say there's a lot of leeway in the minutes within the meeting, you've got to there has to be in those minutes a vote to go into closed session has to be in there. The vote to go out of closed session, say you're in it for litigation, to go into it for property. Again, just a record, minute of who voted which way, and then moving to the session. Then some statement about the general subject matter, but of course you do not have to include in those minutes any detail that would defeat the purpose of the open meeting. And those documents are going to be available to the public. They have to be available within 30 days, even if unverified, not subject to the vote approving the minutes. And there is a second record. In all of the closed meetings, there must be a complete raw audio record. That is normally not going to be available, but it needs to be kept for a review by a court or any challenges. So all the minutes must include date, time, place, names of members present or absent. All matters proposed, discussed, or decided. So you might be in closed session for an hour and a half, cover 4 issues. It has to be clear what those issues were. Names and substantive information from individuals giving testimony, if that's the case. I haven't been in too many where it is, but certainly in some it is. And the votes, to the extent they are votes in a judicial or quasi-judicial, and additional information as requested by any member. I just mentioned 30 days on the written minutes, then they must be posted to the website within 3 days. They must be indicated to be unapproved if they have not been voted upon. The record, the minutes should be available, I mean the really basic recordings of open meetings, I beg your pardon, that must be available immediately. Again, I don't think I can get back, but, and we're going to move on here. The the verbatim recording, raw audio, must be kept indefinitely, must be available for review. Typically it's reviewed by a judge who makes a determination whether it's appropriately a closed issue, whether any votes took place or whatever. There's normally no review from that. Okay. Violation. I've got some really good news on that. I didn't prepare this slide or any of them, as I told you. It is a Class B misdemeanor, but the truth is the fine is not $2,500. It's $1,000 plus a 90% surcharge for $1,900, so you're saving $600 right off, so that's good news. But it is 6 months jail, and the odds are really, really good. No one's ever going to get you in jail for that. But if you do violate open meetings, do it in Salt Lake County, because they will never put you in jail because there's no room. I personally had to know the sheriff and the jail commander when I was the presiding judge, have their cell phone numbers, and if the case wasn't egregious, I'd have to call and say, look, Jim, Roland, I've worked to help you. You've got to give me 5 days for this guy. And sometimes they would do it. But if you violate up here, there's good and bad news. Should you go to jail? 1, you probably won't. 2, if you do, it's where I choose to go. If I'm going to jail, it will be in the Summit County Jail if I have any say in it. It's just a lovely place, as jails go. Okay. Now, one important thing is a court may void any action taken in violation of the Act. That doesn't happen often, but it does happen. And of course, there's a cure. So it really, if it's done and it's inadvertent, you go in and you fix it in an open meeting. So that's not too big a deal. But if we find indeed, and I as an elected county attorney, if I find people are not doing business as is intended in the open, subject to scrutiny, I would definitely take steps to enforce it. I also wouldn't be looking to beat you up or hurt you or anything else. But I would be definitely saying, hey, there's a consequence. And you may have to pay court costs and attorney fees. If there's a private suit, that could be significant. If it's a enforcement action by the county or the attorney general, court costs may be, probably not attorney's fees. Common violations. Okay. Closing the meetings without members of the body voting first in the open meeting. I mean, that should be a no-brainer, but it's easy to just skip by. You hurried, you often could be late or whatever. Conducting a closed meeting for reasons other than those allowed by the Act. This is going to be an area where sometimes you really might not be sure. We've got a few lawyers here, I recognize some. But the truth is, lawyer or not, you can't always make the distinction as well as you should between legislative and administrative. Sometimes it's a combination of both. Sometimes it's judicial or quasi-judicial, or typically it will be quasi-judicial, and you need to understand that belongs in a closed session. But if any questions, I told you how to get the email. My cell phone is circulated everywhere. And I do limit it to 24/7, but if you call me only 24 hours a day, 7 days a week, I will answer. Okay? Taking the official or final action, except the judicial, quasi-judicial, failing to provide the notice, that really is a problem. But again, we're doing this training, so you think about it, it should be just automatic. We're not having any meeting without notice. and we're going to include in the agenda potential closed issues. Let's see. Due process. This is actually a significant one. People can be affected in a business dealing in so many other ways in a closed meeting. And if they never get a chance to see the process, how something was done, never get a chance to address an issue, never get a chance to hear a vote and react to it, there could certainly be a due process violation, which could be a basis for a private cause of action. At that point, you would be dealing with potential attorney's fees and cost. But, you know, due process, it's a right to be heard, it's a right to be informed of what's going on, it's a right to have a fair chance to respond. The standard's not as high in administrative and these types of things as it is in criminal actions, but we all want that opportunity. So just think about, if I was on the other side of this, would I want to be able to speak up, be heard, present evidence? If the answer is yes, don't take a decision until that chance has been, that opportunity has been provided.
Question?
Yes. Where are you?
Are committee members or trustees jointly and severally liable?
That's a great. If you're part of the decision, I think you would be. If you're part of the majority that agreed to take the action or go into the closed session. Now, in terms of a financial liability, jointly and severally, in the meaning it can be all collected against one or split between you, that can vary. But as far as liability, if you're part of it, I would expect you would be jointly and severally, but you would certainly have the same responsibility. That work? Okay. Oh, who can enforce? Hey, I think we're near the end. Attorney General, private citizens, that's through, although a citizen, yeah, this is a good one. You can't go in and say, I got no notice, but I was there. In the Salt Lake soccer field, quite a few of the people, we went 2 days with testimony, and they get on and say, I was there, but it was just lucky. Well, good, you were lucky, but you weren't lucky as far as suing. You don't get to talk about it. That was pretty quickly through. I know most of you are already familiar with it. Do any of you have any general questions, other questions that this raised? Yeah, David.
The litigation exception applies, I think the slide showed pending litigation or litigation that's reasonably
imminent. Mm-hmm.
There are potentially a lot of other legal issues that don't have anything to do with imminent litigation or pending litigation or real estate purchases or sales, that I'm wondering how those legal issues are strategized.
You really have to do it with your attorney present. I mean, not everyone has an attorney, but if an issue requires that, you need to have the attorney, thus getting yourself under the shield of the attorney-client privilege, which is far more protection than you get under the open-closed meeting rules. And I think if you're if you're going to go in there and strategize something that has legal components like a purchase, a sale issue, personnel decisions going to have legal possibilities, that's all just fine. But if it's just legal interpretation maybe is what you're thinking. Now your board's lucky, you're always there. And so tell them you've got a relationship, and I don't think that's necessarily wrong. But you won't be protected if there's no other legitimate reason under open meetings and your lawyer's not there. Okay? Lawyers Full Employment Act, okay? No, but I think it's very important to recognize there are real protections to be had by having your lawyers present. Anyone else? Well, I appreciate you coming. I hope it wasn't too painful, and we'll see you next year. Thank you.